if we don't have that, it's going to be real difficult to try and put together a trial with stand-ins, you know, who we can't get other students. They're not going to say, oh yeah, I have time to read all these cases and get up to speed on being a witness, right? The kids needed to do that for their mock trial, and you know, and in the class, everybody kind of had the same cases, so we just worked it out. We picked a case for trial, and then split them up so they were familiar with the witness statements and whatnot. So,
it's gonna be another professor situation, or we just like change seats and come back.
You know, we'll figure it out. We've always had 2-on-2, right? 2 attorneys on 2 attorneys. And last year I was an attorney, and the year before that, no, we had 7. We had 7 students because I was an attorney in that one as well. So
I call Pete Nolan on my team.
you know, when you're no Aaron Reardon, Aaron's like, I want to go against you. Okay. And then he wished he hadn't. I'll just mess with him. Objection. Objection. You know, not let him say anything. And then just like, sustain. So, and on that note, you guys just kind of reminded me, just took me down a total other path. I kept this tightly under wraps, so I don't know if any of you know this at all. I was, very few at the school do know, I took a bar exam this summer.
Where? Different state?
In a different state.
For Arizona?
No, not over. Nevada.
Oh, how'd that go?
Pass.
Yeah.
I passed. You know, I'm getting sworn in tomorrow.
Oh, wow.
So I don't know, you're talking about Aaron. Like, I wonder how those guys did on there.
They didn't take the bar.
No.
None of them took it in July.
So who took it in July?
No.
Alana?
Alana.
And
Well, somebody passed.
Veronica. Well, no, nobody knows yet.
No, what's her name passed? From,
Nadia took it
Nadia.
last February.
oh, okay. I mean,
And she passed when she took it in February.
okay.
sorry. That's
But as far as July, it was just retakers. So not Nadia, Alana, Veronica.
And they don't find out until November.
Yeah, they don't find out until the week before Thanksgiving.
All right.
But yeah, nobody took it for last year.
I don't recommend it. Taking it if you don't have to. I know you guys need to, but
Does Nevada apply the universal bar exam?
No.
Okay.
No, and that's why I took it. When my wife retired, and last October, we took a trip, and we traveled all over the Southwest, and then went up through Colorado and Wyoming, up that way. And we were kind of just looking to see, okay, where might we want to land someday in retirement, and all of those schools, all of those states primarily are UBE states.
Right.
That I can get in by motion to DC. If I'm an attorney in DC for 3 years, I can get into pretty much any UBE state. So I have a way in to pretty much every state. Nevada's not one of them.
Okay.
And Nevada's like California. You want to practice in Nevada, you've got to take their bar. That's the only way you get in. And it's one of the toughest. It's usually ranked top 5 in the toughest bars between California and Louisiana's always up there too.
Because they're completely different law.
Yeah. And
It's occasional law or something?
It's civil law. Yeah. It's like
It's something
French.
weird.
Napoleonic law. Yeah.
so
It's French. Essentially.
during my transition period, I was studying and
That's cool.
I passed it. You know, so another thing I put down, I told my wife, I said, I'm doing this again. I'm sorry. You got California and Nevada, you choose. I'm not doing this.
Well, if I was on my like 3rd bar exam, I would be doing one of those $12,000 courses.
But you know what?
If I fail it twice with the bar rate, I'm going and getting like a $12,000 course that, you know, sits there with you and teaches you how to do it.
Mhm. It's
I can't
look
wait.
so much of it to.
What's 12 grand compared to like several years of not practicing?
Yeah. But it really, I look back on my exam, and there are plenty of bar subjects that I wasn't all that comfortable with.
Sure.
You know, I studied and I tried to get comfortable with them.
When's the last time you did con law or something?
Exactly.
You know?
Rules and trust, sir.
Yeah, rules and trust, yeah.
But on this particular, there were 8 essays. I got an evidence essay. I got a crim law essay.
So you were happy.
Yeah. I got the performance test was a homicide case, write a motion for new trial on a homicide. I'm like, okay. And so, I mean, just everything kind of broke favorably to me, to what I knew. And, you know, there were some secure transactions, and I'm like, I wrote a secure transaction essay. Didn't feel good about it, but I wrote it. And
No, we're starting.
you know, so it's just a lot of it depends on what classes you were good at, and you know, it's how much do you know, how much can you memorize and just spit out as fast as you can.
Yeah.
You know, and so fortunately, I got that done. I'm not going to do it again. and my firm, it's funny, my firm's already like, oh, I've been wanting to expand. We should think about putting an office in Vegas. I'm like, because they don't make as much in Nevada as they do here. I'm like, well, you know, if you open an office in Vegas, keep me on the same contract, and I go out there. We live in high on the hog over there. Compared, so. But we'll see how that shakes out. So, study.
Yeah.
You know, I've done it twice now, and both times, for the most part, I memorized outlines. That's literally what it is. I took the outlines, and I memorized the outlines, and just spit the outlines out. And whether it was applicable or not, I don't even think it cares. I think they just want to know, do you hit all these things? Because so much of it is they want to know, you want to show that you know things that aren't even relevant to the question, right? You want to be talking about things and say, oh, well, this is a rule, but it doesn't apply here, right? You just want to show it how much you know. And I don't remember any of it now. I took it in July, and as quickly as I took it, those outlines were gone. Gone. So, I don't know. Yeah. Am I on the wrong chapter? What chapter are you looking at?
I'm looking at objections. I don't know why.
Okay, I was gonna say, we're closing arguments tonight, right? I didn't get the
Well, no.
Yeah. I was like, yeah.
I'm like, wait a second. I was looking, Victor's book doesn't look as open as mine. I'm like, I was thinking,
Someone's already page.
425. I know, I was looking at it, I was like, why is it talking about objections?
Closing arguments. You know, it really is the culmination of your entire presentation, and a lot of lawyers will tell you that that's where they start, right? They start, and that's where I start. Okay, what do I want at the end of my case? What do I want to be able to stand up in front of this jury and tell them? What arguments do I want to make? And then plan my presentation accordingly. What witnesses do I need to call? What exhibits do I need in to allow me to make those arguments? And if it's not going to move my argument forward, I don't call them. I don't call them as witnesses. I don't offer exhibits in that aren't relevant to what I want to be able to argue. So for me, I want to be able to stand up and present my case, and that's one of the first things I do is when I evaluate everything is what arguments do I want to make and how am I going to be able to make those arguments. So I plan my presentation starting with my voir dire, setting up my arguments through the whole case to allow me to stand up and do that. And hopefully the argument is the culmination of everything you've put forth in front of them. Right? You clearly have, if you're the people or you're the plaintiff, you have an obligation to point out the relevant law. Here's what I have to prove to you, and here's how I prove that to you. And there's plenty of ways to do that. I have seen attorneys go up there with jury instructions and go point by point by point through the jury instructions. I've seen attorneys go up there and never mention a jury instruction, but yet they're letting you know what it is they have to prove through their words and how they proved it without ever referring to a jury instruction. So, and then you want to demonstrate through the evidence that you presented how you've established what it is you have to establish. Defense on both civil and criminal is different, right? You're trying to undercut what they did. Oftentimes you're trying to distract, right? You may never talk about the law. You may never talk about the evidence that points towards the fact or it doesn't, right? One of the common themes, at least in criminal law, is defense will go up there and just beat up on everybody else. Beat up on the victim and beat up on the cops and the investigation and whatnot, and never mention anything that has to do with the case. And it can be a really good argument because you don't want them thinking about the elements and the facts, because if they do, they're probably gonna point to guilt. So how you do that, how you take the law and the facts and you synthesize them together is it's an art. People that are good at it are just good at it. You sit there and you watch them and it just flows seamlessly. People that are bad are you just sit there and you watch them and it's like, okay. Element number one. I have to prove to you that the defendant was driving. Well, how did I prove that to you? Remember, the officer came and the officer told you that he saw the defendant driving. Remember, you also heard about the defendant's statement where he admitted that he was coming from the store. Okay, yeah, I get it. You've established, you're giving us how you've established that. But you're not doing it in an interesting way. You're not doing it in a persuasive way. Certainly not, keeping them awake. But some people just approach it as a very journeyman-like task. Here's what I gotta do. Boom, 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 boom. And they do it. And without regards to their role as an advocate in convincing the jury that their side's right. And some cases are close. And when they're close calls, sometimes it is your ability as an advocate to persuade them to your side, to convince them that you're right. And you're going to do that through all of these things that we're going to talk about tonight. You're going to play on their emotions, right? You're going to modulate your own voice to emphasize things and soften things as you're going through your argument. You're going to deal with the bad evidence and swipe it aside in a persuasive way that the jury buys into. And so all of those are your roles, but Um, there's no set format on how you do it. They talk about, they try to give you a structure, okay? Deliver a powerful introduction. What does that mean? All right, is it a single line? Is it a dramatic phone call? Right, if you have those things, great. But you've got to keep in mind, by the time you get to your closing argument, they've already heard these things, right? So they're not as powerful as they may have been in your opening argument. Can you deliver a powerful opening, an attention grabber? I'm sure you can, right? There's lines that you can say, and there's ways that you can say it. Don't simply repeat what you did in your opening, because that's not, whatever you did to grab their attention in your opening will seem cheesy if you do the same thing in your close. Well, what I have found is by the time you get to close an argument, you don't need to grab their attention. They're already there and they're already prepared to listen. But you absolutely, if you have something, if you've tried to develop a theme or you've tried to emphasize a certain fact, this is an opportunity for you to do that. I never worried about it. I know lawyers in the DA's office when I was there would just stress. I've got this closed, I know what I want to argue, I know what I say, but I can't think about how I'm going to open. How do I open my argument? You walk up there and you start talking, right? I guarantee you the first words out of your mouth could be, anything. They're listening, right? That's what they've been waiting for too, is the closing arguments, because they watch TV and that's where all the most powerful and dramatic action happens, right? Is in those closing arguments. So that's what they're expecting you to deliver. So to the extent you can grab them, great. I don't think grabbing their attention is as important in a closing argument as in other aspects of the trial, because I think they're ready to listen at that point. But if you can, do it. This says present the law. Okay. You have to, if you're planning for your prosecution, you have to give them the law. Right? You have to demonstrate to them how you what your burden is and how you've met it. Right? You don't want to short shrift that. You never see that on TV. Right? You never see them going over the jury instructions on TV in an argument, but yet you hear those arguments and they're compelling. Argument. So you can do it in a way that convinces somebody that a person's guilty or a person's liable without going point by point by point. I had cases where I rarely referred to the law. I had cases where I walked them through the law step by step. And you're going to have to, for your own cases, you're going to have to decide what is the appropriate level of going through the instructions or not. Some people put the elements in their PowerPoint and then go through how they've proven it. I've never been a fan of that particular method. I think you're what I sometimes would do is I would just mention it. Like law says, I've got to prove 3 things to you. I've got to prove the A, B, C, and D. Or 4 things. Right? And how do we know those things are proven? Right? And then get into my argument aspect, evaluating the witnesses and evaluating the evidence that's before them, getting them to draw the inferences that you want without getting caught up on the law. It seems like there's jurors out there that want to be a lawyer so bad, and they want to, this is their chance, and they're going to go back into that deliberation room, and they're going to try to pick a side, and they're going to pick a contrary side just so they can argue with people, and they're going to try to find technicalities in the instruction that, and if you focus on the law, the jury's going to focus on the law. I always try to tell the jury, this is simple. I always like to give them something to decide, but I never wanted to leave them with the decision of whether somebody was guilty or not guilty. That's dumb. Look, this is a simple case. He's guilty. But you know what? Look, the law says, first degree murder is this. And this is how you get to second. Let me tell you what facts lead us to a first degree conviction. And I would just leave that in their head. Yeah, you got something to decide, but it's not guilt or innocence. It's just a first or second degree. And of course, it's a false choice because it's clearly a first degree, right? But I would leave them with that so they go back there feeling like we've got work to do, but it's fake work. It's work that I planted in their minds that they think they have to go back there and make decisions, but in reality, there's no decisions really for them to make. And that's just a little something that I picked up along the way. Like if you tell them, look, it's just guilty, as charged, done, there's really nothing for you to do here, they'll start talking about other stuff. Well, I don't want them talking about other stuff. I want them talking about what I want them talking about, And so sometimes, I would give them those tasks, right? This is what you're going to have. Let me tell you what you're going to have to decide in this case, And then how do you get them to understand the law, right? I always used real life examples. I gave them anecdotes, hypotheticals, because this is an argument. So you get to tell them how you want them to decide. Right? And one of the examples I used to use that the defense used to hate, but all the jury here could relate to it because before, in the old days, we didn't have that parking structure behind the courthouse that they have now. So parking was always an issue. And during the course of the trial, somebody was always late and they couldn't find parking and they didn't want the judge to yell at them. And so I've set it up that the only thing they have to decide in this case is whether it's first or second. Our theory is it's his first degree because this is a willful, deliberate, premeditated act. This is what the law says about that. And then I'll give them the law. In my words, I won't put the instruction on there, but my words are going to mirror that. The key words I'm going to use so that when the judge reads them the instructions, they're going to get, the judge just told us exactly what Mr. Nolan did. And then I would give them an example, right? And I said, look, so let's assume a hypothetical juror is on a case and they're in front of a judge, a grumpy judge, right? Everybody's kind of laughing. A judge that tells everybody, don't be late, right? You're keeping us waiting. And every judge always does that. And you're running late, and the judge is going to lecture me. All the other jurors are up there waiting. And you come up to the courthouse and you caught at a red light. And you're anxious and you're feeling the anxiety build because everybody's just up there. We can't get started till juror number 9 gets here. And up ahead, you see a car backing out of a stall. Anxiety is relieved. Like, okay, I got a parking spot right up front, I'm just waiting for this light to turn green and set. Then out of your periphery, you see a car coming up on the right. And they've got their right turn light, turn signal on. And you're looking like, crap. But you don't know if they're going to the court or not, but you start thinking, they're going to the court. They're taking my spot. I have no idea where I'm going to park and I have no idea what time I'm going to get to court. And in the back of your mind, you know it's illegal to run a red light. But you start looking in your rearview mirror. I don't see a cop. I look both ways. I don't see a cop. And you hit your accelerator. You just acted willfully, deliberately, and with premeditation as you have driven through that stoplight. That's all the law requires, is that you're aware of the wrongfulness of your conduct, and knowing the wrongfulness of your conduct, you make a decision to act. There's no timing component. Of course, the defense, and when they stand up and you say, oh, you've got to think about this, you've got to deliberate, you've got to weigh the pros and the cons, like, that's not what the law requires. You're not going to see any of that in jury instructions. And so I try to make it so de minimis to them, like, oh, I get that. Now let's look at what the defendant did. Right? And you're going to have to decide if this meets what I've just laid out for you. That's going to be up for you to decide. You know, I believe the evidence supports a first degree conviction. But I never leave them with, I think the defendant's guilty. Because I want in their minds, when I sit down before the defense ever stands up, that decision's already been made. They're convinced he's guilty before I ever sit down, and then I've set it up, and then what does the defense do? They want to undo what I just did instead of making their own argument. They're like, well, you know, premeditation and deliberation actually, you know, it means this, and they try to explain it in more broader terms. That it takes time, and you've got to think about it, and you've got to weigh, and they're buying it. Right? They don't even know it, but they're helping me because they're taking the argument away from guilt into, is this a first degree murder or a second degree murder? Right where I want the jury to be at. So, you know, making the law understandable, that's how you do it. You give them examples, you find cases in the annotated codes that fit what the instruction is that you want to give. And if it's something on your side, you're going to make it as de minimis as possible. Okay? And you're going to want to then incorporate how you've explained the law to them into the facts. And, you know, how you do that is really up to you. I would encourage you to choose your language wisely. You know, I wouldn't simply recount, well, this witness told us this, and this witness told us that, and this witness told us that, and that's how you know this is what happened. But you need to somehow demonstrate how it is that you've accomplished that. Well, let me tell you how it is that we've demonstrated premeditation, right? The defendant, you know, had armed himself before, right? The defendant drove to the location, you know, the defendant called him out by name, you know, the defendant had threatened him in the past, right? You're going down a list. You know, all these things point to, you know, premeditation in our example. All we have to do is show that, you know, you pressed on the accelerator. That's all we got to show. But let me look at all we have shown. And lists can be good, right? To the extent you can give a longer list. I'm not going to tell you, well, this witness came and said this, and this witness came and said that. Just take the key points of their testimony and summarize them in your language and make the points that you want out of their testimony, right? This woman was crazy, right? She left her house, she drove to his house, knowing the cops were already on their way, right? Got out, smacked him upside the head. I'm not gonna say, well, you heard, the officer said that he saw her arrive and she got out. Emphasize the strong points that you want to and get out. And of course, the longer your list is, the more emphasis you're giving it. They're like, wow, they've got a lot of things, right? And you lose that quantitative value if you just go through, well, you heard from Ms. Smith, and Ms. Smith told us this. And then you heard from Ms. Jones, and Ms. Jones told us this. And then, right, the emphasis that you want to get from just pinpointing the exact facts that you want it is gone at that point. Of course, if you have an opportunity to exploit the opposing party's weaknesses, of course you want to do that. Right, if there's something that's there, one of the easiest ways that I found to kind of make fun of the other side is there's always people who aren't called, right? And, why didn't you hear from this person, right? This guy says he was home on a date with his wife. Why didn't you hear from the wife? Is it because she wasn't going to support his version of events? And of course, what inevitably happens is the other side says, "Oh, well, they could have called her too, or they could have called her too." That's the weakest argument, right? You need to explain why you didn't call them, right? Pointing the finger to the other side could have called them is a weak argument. So, if there are weaknesses in the opposing party's case, drive a truck through them, point them out, right? To the extent that you can leave them with no argument, do it. I'd love to slam my case shut right on the front. I've got a rebuttal, so I want to force the opposing side to react to my argument. And you know who does that? People who aren't prepared, right? John Dolan wouldn't react to my argument because he's going to have his own argument prepared. He's going to come up and deliver it. If you're not prepared, you're going to be reactionary to the opposing side. And you'll see attorneys do that in rebuttal, right? They don't prepare a rebuttal. They think, oh, it's rebuttal, I'm just going to rebut the other side. And then that's all they do, right? They're reacting to what the other side says instead of using that as an opportunity to reinforce their strong points. I always prepared a rebuttal argument. And if there was something that I felt needed to be addressed that the opposing party said, I would address it. But if there are weaknesses that you're aware of, don't let them off the hook, right? Use them to your advantage. They talk about using rhetorical questions. Of course, that's a powerful tool because you don't have to provide the answer. Let the jury. And when you ask those questions, sometimes you say at point blank. You know what? There's a lot of questions in this case. What about this, and this? I'm sure defense will come up and explain all this to you in their closing argument. And of course, I've set them up to, are you going to explain this or not? Of course they're not. They're going to stay away from all of those things. Right? And in rebuttal, I guess they don't have answers to those questions. Right? So here's what we're left with. So it's to the extent that you can This is the fun part. This is the argument. This is what you're waiting for, right? This is where the gloves come off. And it doesn't come off in a mean and nasty way. It comes off in, I'm advocating for my position. And for my position to win, your position has to lose. And I'm going to do what I can to represent my position to the best of my ability, and that means there's weaknesses in your case. I'm going to point them out. Okay, and to the extent, good trial lawyers will tell you that there's like this chess match going on and whatnot. It's really not, but there is some thought that should go into it. And to the extent you can manipulate what the other side does to your benefit, do it. Like I said, I used to do it in voir dire all the time. They would kind of stand up because the defense goes first, and they're friendly and polite. Oh, hey, how are you doing? And they're just the nicest people. I get up and I do my voir dire, and they always wanted to respond to mine. Because I was polite and friendly too, but I was undercutting everything they were going to try to do in my voir dire. So their second time they were reactionary to me. And just visually, the jury's like, wow, Mr. Nolan seemed nice, but you seem to be really upset about what he said. But you don't say it in a mean and rude or sarcastic way. It to the extent you can, through questioning things that you don't have to answer, you just have to get the jury questioning them, right? If this were true, you would expect to have heard this, right? You would expect to have seen this. I'm sure they have a good explanation why we didn't. That we'll see what they say about that. And maybe they do, maybe they don't. And then in conclusion, it says, clearly and precisely tell the jury what you want them to do. It's to the extent specificity is required, do it. Right? If you want them to find liability, and you want them to find damages, and you want them to find, these other things, lay it out for them. Right? This is a situation where I have seen attorneys actually put verdict forms on the Elmo and say, see right here, sign this. And then these allegations go with that. Sign the true, get rid of the not true. Right here, this is where you're going to answer these questions about liability. Find the defendant liable. Set the personal damages at this amount. Set the punitive damages at this amount, right? Guide them through that if you think the paperwork process is necessary. I would never do that in my opening argument, right? Because as soon as you do that, what's the other side going to do? They're going, well, no, you don't have to do that, right? Do this and do this. So if I ever wanted, and I never did, but if I ever wanted, I saw attorneys do it. If you ever wanted to walk them through the paperwork, save it for your rebuttal so the other side doesn't have an opportunity to respond. But tell them what you want, right? And I rarely would tell them I want a guilty verdict. I would tell them, I want a first degree conviction. I think the evidence supports that. Right? The issue of guilt is not really before you. And this is a situation where your only issue is this.
Right.
And I'm not asking for guilt. That's already established. I'm asking for the false decision that I've set up for them. Okay? And if it's like a negligence case or something, I'm not asking if you find them liable. Right? The only issue here is on the issue of damages, right? So let's talk about what your options are in damages, right? Clearly, you've got this set of damages what are intended to make the plaintiff whole, right? Here's the evidence that you've heard that establishes this dollar amount. Are those high estimates or those low estimates? That's for you to decide, right? Is it a fair representation of what would make the plaintiff whole? But the law also allows for, damages to deter this type of conduct, right? So what are we talking about? How do we get there, right? I try to leave them with a sense of decision making, when in reality, the decision that they should be making, I'm planning to see that it's already been made, that that's really not a decision they need to make. If it's a close call, maybe you don't, if it's not as clear cut, maybe you don't do that, but tell them what you want, and you should have that down. I believe that after you've heard all the testimony and you've looked at all the exhibits and you've carefully considered the law in this case, then you'll find that the only, correct verdict is guilty. Right? That's not an exciting end. Right? You should have a pat. Here's how I end my initial. Here's how I'm going to jump off of this initial argument. Have it down, but make sure you ask them for it. If you never tell them what you want, then they're not going to know. Okay, what is he actually asking from me? Right? I'm asking for you to find who's been guilty of first degree, and find the gun use true, or what have you. So. That's how you're going to want to structure your arguments, right? Whether you do it chronologically or here's the facts. Some people like to tell the story, they tell the whole story, then they go through the law, and then they point out what areas of the facts present that. You're going to get a sense, okay? And I've got a sense sometimes with a jury, you know what, I got my work cut out for me. I've got some convincing to do. And if I get that sense from their body language and the way they're responding to my argument, I'll spend a little more time and I'll do a little bit more persuading if I have to. If I get the sense they're done, even if it's not in my favor, they're done, they've heard enough, I'm not going to belabor the point. I'll be in, I'll be out, and generally that will score you points with, look, we've heard enough. And you'll be able to pick that vibe up from them. So to the extent these principles of an effective closing argument are new, let's just go through that. Build and maintain credibility. You've got to do that from the start, okay? And you're going to do that through the course of the trial. And you're going to do that through the way you interact with them, the way you interact with the court and your opposing counsel, the way you interact with witnesses. And, of course, when you try to prove small little points, when you're petty, when you're objecting in an offensive way, right? Those are all ways for you to lose credibility with the jury. Credibility is so important because if they trust you, they will follow what you ask them to do. If they don't trust you, good luck. So you've got to maintain credibility. Integrate your case theme, if you have one. Right? And if you were trying to establish a thing, make sure you bring that all the way through to your closing argument. Otherwise, they'll notice. Wait a second, it seemed like you were talking about this case is about greed, and there was greed, and it was greed and money and the evils of greed, and then you didn't even, it's like you threw that out. You didn't even mention that in your closing argument. So if you have a theme and you've tried to use it throughout, bring it home when you close, right? Have a point behind it and bring that home. Okay, that's the whole point of a theme, is to enable you to incorporate it into your closing argument. Engage in horizontal dialogue. You talk to them, right? That's the most compelling way to connect with jurors and to build that that connection that helps with that credibility, is to talk to them, not talk above them, not talk down to them. And I used to see it all the time, just lawyers just, treating jurors like little kids. They were condescending in their arguments, and they were, they weren't really talking with them. And I always made it a point to talk to them. And I tried to talk simply, never use big fancy words, just try to have a conversation with them. And in doing so, I tried to make it a point of having that connection with them. And usually you do it by eye contact and addressing your points to them. And sometimes you'll recognize, right? Maybe a certain witness was called. And when that witness was called, you saw the juror kind of nodding their head up and down. And that was an opposing side's witness. Okay, so maybe you're going to focus your efforts to undermine the credibility of that person with that juror, right? And I used to always know, like, if I'm talking to a juror and I'm looking at them, and they won't look at me, they won't make eye contact, I'm lost. Okay, you're not with me, right? And how do I bring it back? How do I get you with me? It may be too late. You may have already lost them, and you won't even know what it is you did that lost them. But you'll feel it, and you'll know at the end of the trial. You'll know. And this trial hung 11-1 or 10-2. Which one was it? Which two was it? You'll be able to point them out. It was you and you. I know it. And sure enough, it was. You'll just pick up on their vibes, and by paying attention to the jury during the course of the trial, that's how you'll build that relationship. I see people in voir dire reading from their notes, and they're not really engaging them, and then they're direct, they're talking to the witness and the court, and they're never really looking at the jury. You got to do stuff when you have the opportunity to make that connection with them, and a simple dialogue with them. And when we're talking about horizontal, it's right here, right? It's me and you. We're on the same level. I'm not better than you because I'm a lawyer. You're not below me. In fact, if anything, you're above me, right? You hold the fate of my client's case in your hand. So, that's a very strong tool.
So if that's the case, how do you determine between, like, they're not looking at you because they're going to vote against you, and they're not looking at you because it's awkward as hell to look somebody in the eye that you don't know? Because if I was on a jury and the prosecutor, the defense attorney's like looking at me, I'd be like, oh god,
But I wouldn't be staring at them, right? It would simply be a matter of I'm explaining something and I'm talking to them, and if I want them to agree, I'm nodding my head, right? And I'm trying to get them.
Yeah, right. I do want to though. Like it is natural to be like I even started
So if you agree, you might be like, yeah.
well, no, it's even natural just to be like,
Yeah.
like it doesn't even doesn't matter if it's like, you know what I mean?
And if you want them against it, right? It's just those little things like, well, that doesn't make sense, does
Make
it?
them engage.
Right? And most jurors are going to try not to give any clues,
Sure.
but they're humans, and they will, and they'll smile at you, right? It's like, okay, all right, I got you. I'm not worried about you anymore. Right? So
You're gonna read the
your
room.
hand gestures, and they get right up on the bar, right up on the bar when I'm arguing, and I'm talking to them. So that there's that proximity, but I'm not talking down to them, okay? I'm talking with them and pleading your case, right? Making your arguments. And let's keep in mind, it is an argument. So, right, the 4 principles, employ the tools of argument, right? What makes for a good point? Right? If it's a good point, they get it, right? You make it and they get it, and you don't have to beat that up and down, right? Some lawyers think like, well, this is a good point, so I'm going to tell you 20 times, you get it right, and after about the 3rd or 4th time, you're like, okay, we've heard you say this already, why are you telling us this again, right? We got it the first time.
And you start losing other stuff.
Right.
If you're not listening, yeah.
So don't rehash. Point out the points that are good, and minimize the ones that aren't. Right. Use your rhetorical questions. Use your analogies, your anecdotes. Use stories. Right. To me, I never understood. If I want to explain the law to them, I gotta explain it to them, right? And what better way to explain it than to use stories and anecdotes? That's what they want to hear, right? When I'm telling you about this juror, who's pulling up to the courthouse and it's a red light and anxiety that's building up in them, they're feeling it. It has absolutely nothing to do with the case, nothing. But I'm engaging them in a story that they're listening. They kind of want to hear how it's going to end. And then when I finish it, it's like, oh, I get it, right? So I don't have to go back after I've told that story and say, so, you see, premeditation doesn't take much. Why? I've made my point. As soon as you hit that accelerator, you've just acted willfully, deliberately, and with premeditation. That's all it takes. I'm done. I'm not going to come back and rehash that. So do you see how that's all it takes? Let me explain my story to you. If I'm explaining my story to you, I've lost the point. So there's nothing wrong. And I like to use stories and hypotheticals in my voir dire. So by the time I get to my close, especially in my rebuttal, because I like to spend most of my voir dire undercutting what I believe are going to be defense arguments. And by the time they come in and they make all those arguments, I can stand up at my rebuttal. Remember we talked about this? And they're like, oh, yeah, remember the example I gave you? That's exactly what counsel's trying to do here. That's not the law, right? And so you can undercut them, and you can. There's nothing wrong with talking about what happened in the trial. I remember how counsel reacted when I asked you those questions in voir dire. Remember how defensive he got, right? And you can point out the way people act, the way they were on the witness stand, right? Did you see when I asked that question and witness gave me a little smirk? We all know what that smirk meant, You don't have to explain what the smirk meant, right? You just want to point out, and everyone's thinking, he's smirking, not smirking. Well, I've established credibility, so of course he's smirking. and nobody else, maybe they saw it, maybe they didn't. Right? Remember when right, we called this one witness to stand? Did you see made eye contact with the defendant? Did the little head nod? Right? That's not in testimony, but it's an event that happened during the course of the trial, and somebody saw it. Right? Maybe all 12 didn't see it, but somebody saw it. If you saw it, somebody else did too. And pointing those things out, and I don't go overboard with the court. I'd like the record to reflect that the witness just head nodded, to the defendant. The judge is saying, counsel, move along, right? I make a mental note of it, and I bring it up, and I slam it, down their throats when they try to say, "Oh, we're not working together on this." Of course they are, right? That's the universal sign of saying, we're good, I got you, we're all right. Is that the universal sign for that?
No.
I just told you it was, right? And you trust me. You've been doing this a long time. I'm not all that familiar with the world of gang members and gang violence, and yeah, I guess that is the universal sign for you're good, I got you. Right? So to the extent you can use analogies and use your anecdotes and use stories that are unrelated to your case, those can be powerful tools. And of course, appealing to common sense, that's just basic. I think most people on a basic level, if you tell them, let me tell you a story. This happened. What do you think? They're going to tell you, without knowing any law or any persuasion, they're going to think, I think that guy did it. I don't know if he did it. They're going to use their common sense and come to a conclusion. And there's nothing special about being on a jury, and you don't need to have any special training. You don't need any legal experience. You just come in and you use your common sense, and that can be very powerful in the field of persuasion, especially if what the other side's asking them to do just doesn't make sense, right? If they're trying to push the envelope of reasonableness, and it just doesn't make sense, kind of like Johnny Cochran. If it doesn't fit, right, you must acquit. Now that was just a catchy phrase, but the point was there, like, if it doesn't fit, it can't be his, right? If it was his glove, it would fit it, right? That was an appeal to common sense in a way that, those jurors went back there and repeated that. One of them or more of them did. Yeah, if it doesn't fit, you must acquit. Right? They just remembered that. But on a very basic level, he was appealing to their common sense, saying, we all know that. Your gloves fit you? Yeah, you slide them off. They're your gloves. And maybe you hit the fingers because they didn't quite go all the way down, but you don't have to struggle to get them on, right? But he didn't have to say that, right? He didn't have to go into that type of analysis to make his point, right? He made his point and let them jump to those conclusions. Right? If you've got demonstrative aids and exhibits, use them. If you've got powerful photos, use them. If you got a weapon, show them. Right? If you've got timelines or diagrams or anything, they like to see those things. Okay? As much as they say they don't, that don't tell you they don't, right? When you see there's an accident, you're like, just go. And everybody's looking, right? Well, I don't want to see anybody hurt. I don't want to see any blood, but I sure want to look, right? They want to see the stuff that that you have, okay? And if you've got some pictures and you've got weapons and things like that, pull them out, use them, remind them. Right? When I had my dog, I had a picture of the dog that I put into evidence just so I could put it on the Elmo when I was talking about her. Just little things like that. Just know that if you're gonna do those sorts of things, make sure you know what you're doing. Yeah, and what I mean by that is, I saw a DA, pull out a rifle, and it was a rifle that was in evidence. It had the cables through it, so it was inoperable and you couldn't use it. It wasn't dangerous or anything, but she got it and she tucked the stock under her arm, not up on the shoulder, but under her arm, and held it down here. And so, how do we know about the defendant, right? And what he did was, and she's pointing this gun all over the jury, right? And if you know anything about guns, you are freaking out. Like, have you ever been to a safety class? You never pointed. I don't care if it's inoperable. You never point a gun. And
bailiff wasn't
you would see jurors like they were leaning back. Why didn't she pick up on that? I saw him do it. And she's just like, and she's trying to tell this story.
No, looking at the gun.
Right? If you're gonna use a weapon or a jackhammer or something, make sure you know what you're doing. If you're gonna handle it in front of the jury, if you don't handle it in front of the jury. Okay? Right? If you do, do it. Practice if you want to. So you know how it is you want to use it in front of them. If your evidence is this guy was, holding a knife like this and he was stabbing, you lose that if you hold a knife like this. Say, well, you've heard the evidence, right? The defendant came in and he grabbed the knife and he stabbed him. And they're like, well, wait a second, that's not, if you're going to demonstrate, make sure you're demonstrating accurately what you did, or what you want to. Those things can be powerful, but you want to be comfortable with them, right? Recognize the limits of your audience. Okay, I always try to be brief. It was just something that I always used to feel about. I remember being told that, look, you got like a 20-minute window where you can really be effective. And I never tried to go over 30 minutes in a closing argument. I did on occasion, but I tried to be short and get in. And I always tried to keep it simple. And that was a phrase I used to tell them. This isn't a complicated case. This is an easy case, right? You guys are lucky, right? Some cases are difficult and jurors labor over, their decisions, right? This isn't that type of case. That doesn't mean you don't have a job to do, right? So what is it that you have to do in this case, right? And then I would lay out my argument for them. But sometimes I would say that to them. This isn't a difficult case. This is a simple case. This is an easy case. If it's not, you're losing credibility with them. Okay? So make sure that if you're telling them that, you can convince them of that. If you tell them this is an easy case and you sit down and they're like, don't know. That seems pretty difficult to me. Then you've lost that argument. If you're going to tell them that, show them, lead them to how it is that it's an easy case. Adopt a persuasive style, right? Understand and utilize nonverbal communications, right? That's the head nods. If I want them to agree with me, I'm nodding my head, right? I'm taking notes, right? That just doesn't make sense, does it, right? I'm using my body language to enhance what my word is saying. Because they'll hear you, but are they truly, some people, they're picking up on the body cues as well. So by utilizing those, those little tricks and those little nonverbal cues, it can be very effective in helping to persuade them. Right? Eliminate barriers. Right? That's any distraction. Okay? I never like to use a podium. And when I got the podium, I pushed it over to the side. I had notes right there. So if I needed to, I could come back and look. And then I stood in front of them. And when I wanted to emphasize a point, I walked closer. And then I'd walk back in front of them. And then I'd walk closer. Right? And I'd modulate my voice. And if I wanted to point something out about the defendant, right, I wouldn't be on this side. I'd be up closer to the judge, and then I'd open my body and point, right? If I'm standing in front of the jury and then saying, well, let's look at the defendant. Well, I'm blocking half the jury, right? Some of us block more than others, but I'm blocking half the jury. And so if I'm going to do that, think about it. What am I doing? Am I presenting barriers to my own presentation? You go over there. I never used PowerPoint, so it wasn't an issue for me. But if you use PowerPoint, where's the juror's eyes?
On PowerPoint.
They're all over there, right? Because here, the Elmo is over there. And I would see lawyers stand in front of them, and they're like this, and all the jurors are looking over there. They're not even looking at you. Give your argument.
Seems like they don't just kidding.
But if my screen is over here, guess where I'm at? I'm over there by my screen.
That's where Sheila Williams stands. She stands, the screen is by the jury.
Mhm.
She stands by the jury box with the podium. So they have to look almost past her.
Right.
You know what I mean?
Yeah. If you're going to have them look at that,
It's behind her.
get there. Get there and put nothing on your.
To the judge, it was a judge trial. So the judge had to look at her with the screen
Mhm.
behind her. She was like almost in the well.
Right, but the concept's the same.
Yeah.
Right? Right. If this is a jury box, right, and the Elmo's over there, I'm not going to stand right here. I'm going to go stand over there. So you're looking at me as you're looking at the screen, and you're not talking to them, right? Little hits, right? And I never like to fill up. I've used PowerPoint in trainings and stuff, but I've only used it in 2 trials and didn't like it, mostly because they weren't looking at me. Don't put a lot of information in there. Control it, right? Here's my title, right? Let's talk about the defendant's statement, okay? And there's nothing up there. All it says is defendant's statement. So if you want to look at the screen, you got nothing to see, right? And I'm going to talk to you about it, right? How did that come about, right? What were the circumstances that led to him giving this initial statement, right? And you're having that conversation, right? And so what did he say, And then something comes out, admission, right? Then that's all it says. Don't list the admissions on the PowerPoint. Come back to me. You want to know what his admissions are? I'm going to tell you what he said, right? And then you lay them out, right? Inconsistencies, Right, now let's talk about inconsistencies. If you just list it, no need to even be up there because they're reading it. They're reading everything that's on the screen. As soon as that page jumps up there, they're going to go top to bottom, regardless of what you're saying. That's a distraction. You know, and if you want to just hit some bullet points, hit them one at a time. Let them come up on the screen one at a time, right? There's that animation function that allows you to do that. Don't put them all up there because they're reading them all. You want to manage the message that you're delivering and how you're delivering it, right? If you have 4 things you're covering and the last one is inconsistency, and they've read that, before you finish your first point, that juror is already thinking, oh, what were the inconsistencies? Oh yeah, you asked him about this and he had said something else somewhere else, right? And you're losing the impact because they're putting the filler in there. You want to put the filler in there. So take anything that you can, whether it's physical or not. Some people use a podium, okay? Some people feel they need a podium, right? But there's something about standing up there just yourself that allows you to make a connection that I think is lost behind a podium. So that's why, you know, you decide what barriers you want to eliminate. And, you know, early on in my career, I never just walked in front of the jury. I always was behind the podium. Maybe I walked in one side of the podium or the other side, but I never just stood up there. Probably about the last 10, 12 years, I always just moved the podium out of the way. And for the most part, I always had a hand in my pocket. I had a hand in my pocket, and I was with one hand. Then I come over here, my other hand, but it just went. And I must have been told 1,000, 2,000, 5,000 times, you gotta get your hands out of your pocket. You know, I was successful leaving my hands in my pocket because I was comfortable that way. And when you're comfortable, they pick up on that. If you're not comfortable in how you're talking to them, they're gonna sense that. That's why it's so important that you are yourselves in front of the jury, because if you're not, they know you're not, and they're gonna pick up on that. So it's hard to copy somebody else. It's hard to say, I want to do just what you do. There's techniques that you can try to incorporate for yourself. There's arguments. Hey, I like the way you argued that. I want to make that argument my own. But if you want to just copy somebody, it doesn't work that way. Unless you pick somebody that's a lot like you that has a very similar personality, it doesn't work. They pick up on the genuineness of you, and lawyers are some of the fakest people out there. We just are. And juries pick up on that. You know, oh, this is a stick, that you're doing. This isn't even who you really are. And putting down that barrier and letting them see you for who you really are, I believe makes your presentation that much more compelling to them. So display passion, conviction, right? Use logic and emotion. You've got to convince them that you believe in it. And your passion and your conviction can be through strong language. It doesn't have to be through raising your voice, yelling at them, right? But there's a time and a place for that. And if it's there, use it, right? Use the emotion that your case has. And if there's righteous anger to be discussed, show it, right? If there's sadness and emotion to be had, let them feel it, right? Slow your pace. Talk softly. Talk slower, right? Let them really emphasize the emotion that you're trying to emphasize to them. pause. If you want to make a point, say it and wait. Let it sink in. And you will see the emotions build up in the jurors, right? It's not uncommon for jurors to get emotional. Let them. Encourage it. Bring it out of them. And if you can, it's very powerful. Right? If they're connecting a conclusion with the emotion that they felt, you've won. If you can make them feel the sadness and the loss and the anger that your party has, it's very moving. And you manipulate that by the way you present. Right? If you're monotone, same volume, same pace, same speed throughout, you're losing a huge opportunity to play on these sorts of things. So, and sometimes it's okay to show your own emotion. You know, I did plenty of trials where I use these tools to play on emotion. My very first death penalty case, it hit me. It choked me up when I was talking about my victim. And jury felt it. You know, you can't fake it. You can't stand up there and fake emotion. They feel it. They know if it's real or if it's not. And they did. And I turned around because I didn't have anything else to say. You know, I had more in my argument than I wanted to say, but at that point I knew, okay, this is done. And it was powerful because not only was it hitting me, I could see it hitting the jurors. And one of my prouder moments, when I turned around, the defense attorney was in tears as well. I'm like, wow, this was powerful. It even impacted him. So, you know, don't be afraid to use those sorts of things in your argument. Prohibitions, right? These should be no-brainers. Don't mistake the evidence. Right? That goes back to the biggest thing we've told you. Maintain your credibility. As soon as you're saying, remember this witness said this? If they didn't say that, or you're twisting it to kind of fit your side, they pick up on it and you lose credibility with the jury. Don't mistake the evidence. Don't exaggerate the evidence. Emphasize the evidence in a way that works for you. Okay, and your case. Personal opinions, you can't do it, right? You don't get to say, well, so what did you think about Mrs. Smith? I found her believable, right? You can't do that, right? You can't vouch as a lawyer, right? You know, you could say, you know, here's how we know what she said was the truth. That's an argument. That's not my personal opinion. Let me tell you how you know that you can take a Mrs. Smith testimony to the bank. And then you point out all the reasons why she was credible. Maybe it was her demeanor on the stand. Maybe it was her consistency over the course of many statements. Maybe it was corroboration. Other evidence supported what Mrs. Smith had to say, right? But there's a difference between saying this person's credible and I, the lawyer, believe them. You see the distinction? Tell them they're credible. Don't offer your own personal opinion. Like any sort of arguments where you're being asked to put somebody in the shoes of somebody else, don't do it, right? And stay away from that. You don't want to, you can't ask them to sit in the place of anybody else. But, you can ask them, common sense type questions, right? If you had just been hit by a car, common sense would tell you, if you're able and you've got a phone in your hand, you might dial 911, right? And when you dial 911, you might tell them what happened, right? So I'm asking you to kind of go into somebody's shoes, but I'm not asking you to, right? And what happened in this case, right? They didn't call 911, right? They went home first, right? And then they called, and then they changed the story, right? So you can ask them about events like, that just doesn't make sense, right? You would expect somebody who has experienced this to act this way. And that's not what you saw, right? Your common sense tells you that's not believable. As opposed to, if you were in the defendant's shoes, you could call 911, right? It's a different argument, but it's the same. So there's ways that you can get into these arguments without, and that's just, excuse me, that's just experience. You'll see how attorneys do it. You'll pick up the little tricks, and you'll be able to do it, without even thinking about it. Once you learn how you go about doing it, right? Clearly, if there's excluded evidence, you gotta stay away from it, right? Clearly, if it's excluded in like a pretrial motion, easy, right? The jury hasn't heard it. The problem comes in, right? You ask a question, a witness gives an answer, opposing counsel objects, and the court strikes. Okay, that evidence is out, but everybody's heard it, right? Can't argue it, That's where you get into trouble. I've seen attorneys too, right? They know what the evidence is because you know all these facts, and sometimes you just get into it and you start arguing the case, not necessarily from a perspective of what was presented in the trial, but what you know about the case, and then you mention something that never came in. And sometimes you're arguing something, maybe it wasn't excluded, but it was something that nobody presented. So it's still an improper argument to refer to evidence that's not before the jury. Avoid disparaging opposing counsel or opposing party, right? That goes just to maintaining your credibility and your professionalism. To the extent appropriate, you've gotta really you've gotta weigh it. I've had times where defense argument went so far afield and crossed the line, I called them on it. I stood up in my rebuttal and I laid into them. I laid into them with the way I argued and the words that I said, right? I didn't necessarily disparage them, right? Sometimes that's just an optical thing too. Right? Wait a second, I just gave my whole argument and I'm talking to the jury, right? Now all of a sudden I'm arguing and I'm telling you what I want you to hear, but I'm looking right at defense counsel as I'm saying it, right? And I'm arguing counter to what he just suggested and what he did. And I'm pointing and I'm making my points that I could just as easily be making to you, but through my body language, you get exactly who I'm talking about and who I'm talking to. And that's going to be a rare case. I had one case where the defense attorney just really laid into the investigating officer, just laid into him, called him every name in the book. I objected, and the defense, the judge said, "Oh, this is argument." Okay, and he just went and went and went, and he kind of ended with, "I hope if any one of you ever lose a loved one, that Investigator Patterson isn't called to investigate." And that's how he ended. And I defended Investigator Patterson vigorously, and sometimes it's how you do it, right? So I remember that argument, right? As soon as he turned and kind of while he wasn't even sitting down yet, I'm up. And I'm not waiting for the court to say, "Mr. Nolan, your rebuttal." I'm up and I'm ready to go. And walk straight over to him and, "How dare the defense disparage the honor of this man?" Right here. I'm talking to the defense attorney, the jury's behind me, but they get it, right? They know exactly what I'm doing without me. I didn't call them names, right? I didn't disparage him. I rebutted what I found the offensive parts of the argument that he had given. That, and I had one case where I think I've shared with you, I had a case where the defense attorney was just slimy, and he suggested something to one of my witnesses, and my witness was like, "Oh, yeah, the police report says that, then that must be true," and just proceeded to go down this whole laundry list, getting my guy to admit to 30 different things, none of which were in the police report. He never said that. I remember I was calm and cool and collected, and we got through the whole case, and I argued, defense argued, and he kind of crossed the line in his argument, and I came up in my rebuttal more impassioned, right? Just more, energy, if you would. And I remember that some of the jurors came back after that trial. They convicted him. They said, we really needed that from you. We needed to see your passion and that you cared about this case. Because up until then, it didn't seem like you really did, right? Okay. But, and you'll feel when it's right to go after a witness. You'll feel when it's right to show emotion, even anger, in a closing argument. And don't be afraid to use it if it's appropriate. Because the jury will be there to pick up on, yeah, that was appropriate. And I say it says avoid disparaging opposing counsel or opposing party. There was a DA, he was senior to me when he was in the DA's office, every case he used to file in his trial brief, he had this section that allowed him to use colorful language. And it's okay to use colorful language, and you can get up there in front of the jury and cuss if you want to. Right? That's not illegal. There's no prohibition on it. And that was his personality, and he used it. He would get the court's blessing that he could use it. He would discuss it with the jury in one ear, right? And get them on board with the idea of him using colorful language during the course of the trial. And in his closing arguments, the defendant is a fucking liar. And let me tell you how we know. And he would do it. It fit his personality. That's who he was. So it helped him bond with the jury. He was extremely successful. I would never try it. I could never pull it off. He did it. And he made a career out of it. I mean, he was top prosecutor in the county for like 5 or 6 years. It was like, wow. Everybody loved to go watch him in trial because,
He swore
it was
entire
going to be, usually in closing, but it was entertaining. But if you know him and you interact with him on a day-to-day basis, that's who he is. He's one of those guys that's just like, dude, sit down. I'm getting tired just watching you, right? And he's just up and he's always moving and he's kind of twitchy and he's just, he's that guy. And I was like, calm down, dude. But because that's who he is, that's his personality, that the jury saw him and they were comfortable with him. And it didn't come across as contrived or whatnot. Of course, you want to avoid any sort of racial, religious, ethnic, economic bias, but don't be afraid to address those topics. If those topics are part of your case, don't sugarcoat your case, right? If this was a freaking race-related crime, call it what it is. You know why he killed him? Because he was black. That's why he killed him. He's a Hispanic gang member from Southern California, and their motto is no blacks, right? Or however they say it, right? And if they use colorful language, don't be afraid to use it as well, right? If they use the N-word as they were shooting him down and witnesses heard it, don't shy away from reminding the jury of what exactly it was that they did. Of course, make sure you're not asking for any sort of grandiose assertions, right? That they need to be sending a message or anything like that. That's not their job to send a message to society. But there is a way that you can discuss those things without saying those things, right? We need to hold this defendant accountable. You find the language that works in your case, right? This one I kind of disagree. It says avoid comment on a criminal defendant's failure to testify. Absolutely cannot do it. Don't talk about it. Or to produce evidence. You don't talk about their failure to produce evidence, but you absolutely comment on their failure to call logical witnesses. If they've got witnesses that would just make sense to call, and they don't call them, you point it out. Why didn't you call this person? Right? It would make sense that you call them, right? They didn't do it, so you can infer from that exactly why they didn't call, because they're not going to support his contention. Avoid urging jury nullification, right? That's basically when you're asking the jury not to follow the law, but to do what's right or to do what's just. I know the law says this, but does that seem fair to you? Can't do it. There's some defense attorneys in the criminal world that do it. Some are blatant in their attempts and they're not good at it. And some are very good at it. And it's very subtle. It's like, crap. I want to object, but that was actually pretty good. So, have a strategy in closing. Right? I rarely objected in closing argument. And one of the things that you see young attorneys do, it's argument. Right? So the opposing side will stand up and say, well, this witness said this. And they're like, objection, misstates the evidence. And the judge always says the same thing. Ladies and gentlemen of the jury, you heard the witness, you recall what it is they said and they didn't say. And they're never going to agree that the attorney's misstating the evidence. So you just seem petty on that. Sometimes it's appropriate to object, Sometimes it's strategic, if they're way out of hand, you object. If they're on a roll and they're just going and they're scoring points and you see them scoring points and you see jurors nodding along, it's like, I gotta stop this. I gotta stop the
Mistakes the evidence. Ladies and gentlemen,
Objection.
it's just argument. Right in the middle of this argument.
So have a plan. I hated people objecting when I argued, especially when I was on the roll making a point. It just throws you off your flow.
It's not exactly what we do on
That's the point.
And I used to hate it, but you get it. And one of the things, this is just a practical advice. I never looked at opposing counsel when I was arguing, and I'm talking to the jury. And if they objected, I'll see lawyers turn around and look at them. I never did it. I made a point that I would never object. And kind of how like Dean Dolan says, you go up and somebody objects and the court rules against you, and you're like, well, thank you, Your Honor, and you act like he just ruled in your favor and the jury doesn't know. Let them object. They object, I'm not even looking at them. The court says whatever it's going to say. Sustained, overruled, I'm right back into my argument. Okay? And I never really even acknowledged that the other side is objecting. I'll pause, let the court do what they're going to do. If they asked for, my position or what my thoughts are, I would turn to the court and give it to them. I would never acknowledge defense counsel. It's not that you can't, it's just that I wouldn't. Okay? And if they know that they're getting to you, they're going to keep doing it. Right? And, if you're looking at them and you're, they're like, oh, okay, this is working. Right? If you don't even look at them, it's frustrating. Like, I'm trying to get to you. You're not even giving me the benefit of that. So, questions? Closing arguments are very personal. Cases that you feel strongly about, you're going to argue more passionately than the cases you don't. The trick is being able to channel that passion and emotion on cases that even when you don't feel all that strongly about, and coming up with a way to argue that is persuasive and interesting, keeps the jury involved in listening, is a key. And there's no, for me, from a structural standpoint, I've argued probably 15, 20 different ways as far as structure goes. there really is no set structure, and you find out what the facts of your case lend itself to, and argue accordingly. So next week we'll practice. So what do you want to argue?
We'll stick with the firefighter case.
Okay.
Preloaded.
So you're going to argue the plaintiff's case and can't be bond.
Yes.
And what are you feeling?
I feel like I kind of have to do the prosecution case in the criminal matter.
Or I'm gonna run away with it. Right?
Yeah, well, not. I don't care, but I mean, how does the defense go if there's nothing? Well, I guess they can just form their own argument. But
Go for it. I'll have to take you on.
no, I'm gonna do the prosecution.
Okay.
I,
And you'll do the
that's
defense?
when we, yeah.
You'll do defense? I'll probably throw together a little defense argument for you, just so you can rebut it.
Oh man. All right.
Okay?
All right.
I mean, I can stand up there and give one, but
So.
this guy's a drunk idiot. Thank God he has no toes and isn't running into a burning building anymore. We're watching to save me if he's not coming with the proper shit.
All right, guys. Good night. Put some work into it. Everything you need in the book. It's got your jury instructions and all that. So, incorporate what you need to. And just assume whatever's in there you can argue. We've had no 402s, and to the extent we had 402s, we let everything in.
Your client's crazy.
I've already been thinking of arguments against that. So, but as far as like testimony goes, are we only going off of like what we said in class? As far as like you've heard during the trial?
Assume that,
Or just assume that all the evidence is favorable to our side, or?
if it's favorable to your side and it's in the book, assume that they've heard.
Okay.
Assume that they've received it.
Okay.
That was
That was the big problem that I had with directing the cross was I don't know like what I can get in, what I like. Okay. So just assume if it's in there, they've heard it.
They've heard it.
And what we got in effectively is kind of different than what we got in, right? Because, I don't know, that's actually an interesting question for another time, but like, what do you do at closing when you don't bring something effective? Like, you bring it out, you can argue it, but you didn't bring it out very effectively. Like, how do you mitigate your own screw-ups?
Yeah. So you didn't bring it out in a way that allowed you to argue it the way you wanted.
Well, you want to argue it.
Maybe you stay away from it, right?
Yeah.
Everything they heard that
Because you can only bring up what they've heard in trial, right?
correct.
You can't bring in new things during
Well,
closing
you could
argument.
bring in, of course, reasonable inferences from what they've heard.
Yeah,
You know,
but nothing new.
nothing new.
Oh,
Correct.
Thanks for
All right.
More, sir. 5 new.